subscribe to our channel and press the bell icon to never miss a video from LiveLaw.
Since there is a judgment, he'll proceed on that presumption. But I am not a sitting judge any longer. So I can say that it needs reconsideration as far as the system is concerned. And whether India is the only country where judges appoint. That is one. Then presuming, actually maybe on papers and going by Indian conditions, it may be one of the best even today. But in its working, again, Dhananjay in a very subtle manner accepted the fact that the Collegium system may not be working that efficiently today and it needs changes. He has said in two judgments, one judgment which he quoted and the other judgment, he and Justice Sanjeev Khanna was sitting there on where the CGI is now, office is subject to RTI. There also lot is said about, of course, it was in the context of whether when the this process is undertaken for appointment of judges, whether it should be made public, etc. or not, and public interest on the one side and the right to get information on the other side. In the whole process, both of them have discussed. At the end of the day, let me be very frank and blunt by saying so. What Shekhar, you said about that, how we get to know about the, as far as a particular judge is concerned, from High Court to Supreme Court, if he has to come or she has to come, or from District Court to High Court. As Dhananjay also said that, yeah, we have the process of evaluating their judgments, etc. But still, I would say most of the time, we go by our impressions. It may not be a scientific study made about a particular candidate, if the candidate is chosen from the bar or from the bench when it comes to Supreme Court. And the Collegium goes by this, and therefore, many times those may be aggressions, those who are taken, they may not be deserving, and many times those who are deserving are left out. So that needs to be taken care of.
I think that's it. I think we've got onto a very healthy track. So,
I think given the aberration, given the constraints of the system, the cases which you mentioned at the start were, I think, aberrations. I think given the constraints, we really do have, it's amazing how the system does throw up a lot of very excellent judges who are willing to give up lucrative practices to be in judgeship. So I think that is important also to acknowledge, while also acknowledging the fact that I think we do need some, given the range of issues that the court is deciding, particularly our higher courts, we do need some kind of, just having judges or just being a great lawyer is not necessarily to make a good judge. So when you have issues like 377 or environmental issues or issues which, a lawyer may not have, the legal knowledge alone is not enough. You need a lot more social sensitivity. And therefore, I think the system has got to be able to pick up people who may be able to assess, as to whether a person has a good sort of social sense, a breadth of experience outside of the courts. That's important in our system particularly. And when we talk of diversity, I think, particularly when it comes to women, it's interesting that a couple of weeks ago, I met a senior counsel, a woman, who mentioned that she had missed out on judgeship because she spent the first several years, being a stay-home mom because she wanted to be with her child. And then by the time she got into practice and did very well for herself, it was just too late. So should the age be the same for men and women if women have families? How are you going to take care of that? And we may be missing out on some very good candidates because we don't take that into account.
Very valid argument. I will use the opportunity also to speak with my consistent opinion for a long time that 62, 65 is too early for judges. That, just as IIT professors have been 70 now, that this is the post-statin era. Our arteries stay cleaner much longer. So people should, particularly people who have attained that level of eminence and experience should serve much longer. So Chintan, the other big change on the Indian legal scenario, and I think that is what is resulting also in better quality judgments now, better arguments, judgments with greater clarity, is how legal education is improved. The rise of national law schools, and in their way, just as the IITs then set the bar someplace, and then many degree colleges grow, a lot of good legal education is now happening. So, how much of contribution is that making to this change right now? Because even journalistically, we look at a judgment and we make up our minds very quickly because we find it forbidding to read judgment. The Sabrimala judgment is an example. The moment Sabrimala came out, everybody said, "Oh, what a strange judgment that all the men have voted on one side, and the women judge voted on the other side." But only when you read her order, dissenting order, I just thought this was one of the most beautifully argued judgments because she was not looking at it in gender sense. She was looking at it in the sense of what's your problem, right? You are an interloper. And the point was that then anybody will then muscle his or her way into any other faith issues and there will be a free for all. It was a very well argued judgment, but most of us normally would not have read it. So I was privileged because I had law graduates who are now working as journalists who could point this out to me. But you think we are now seeing that change? We see scholarship come back into judicial practice.
So Shekhar, before I get to that, I will respond to your question. But before I get to that, I can't resist but comment very briefly on the NJAC and take off from where Justice Sikri left it. I should emphasize that this is my personal opinion. It shouldn't be attributed to anyone in the family. But my view is that a large number of both sitting and retired judges had taken the view that the Collegium system simply wasn't working. And the best demonstration of this was that many leading advocates were refusing to take up judgeship, and many leading High Court judges were not being elevated to the Supreme Court. And I think there are two important things that we need to remember about the NJAC. One is that it was the product of a bipartisan consensus. Remember, this was not one of those statutes where the opposition staged a walkout or where the majority tried to push through parliament. The second is that it's also interesting to think about the fact that the court didn't give an opportunity for the NJAC to play out in practice. And if you consider many of these the judgments that I look at in the book, for instance, take the national security cases. There is a gap of a decade, often 2 or even 3 decades, between the legislation coming into effect and the legislation being challenged and the challenge being considered by the court. Now, what's the benefit of that? The benefit of that is that you not only have the experience of what the law says, but you have the lived experience of how the law has operated in practice. So I think the court may well have chosen to do one of two things. So one, give it an opportunity to play out its practice and see how things transpire. And second, there could have been some amount of remedial creativity. I mean, typically we always assume that the court just has two options, uphold or strike down. But in practice, really there's a spectrum of options available to the court, and it can strike down with reservations, uphold with reservations, and the like. Coming to your question, Shekhar, the national law schools, the emergence of the national law schools has undoubtedly made a difference to the availability of solid legal scholarship in India. And you see this being reflected in the judgments as well. Because it was very common until perhaps even 10 years ago for Indian Supreme Court judgments either not to engage with scholarship at all or to engage with scholarship predominantly from overseas. I think that's now beginning to change because you often have judgments that are engaging not only with international and foreign scholarship but also with domestic scholarship. I still think that there's somewhat of a problem here, which is that not enough of the best candidates are being attracted to academia within India. So a lot of the finest scholarship about India is still being written from abroad, from foreign universities. And as they say, there's an old saying that the Indian Law Journal, as opposed to the blue chip foreign law journal, is the graveyard for all Indian scholarship. You put it there and it dies a slow death. So there are some things that need to change, but at least the direction of travel is right.
Thank you very much. That's very nice. Now I'll ask. We just have about 3 or 4 minutes left, and I know we've been very punctual here. So if each one of you could mention the last 10 years, when some Chintan Chandrachud writes a book like this 10 years from now, or 20 years from now, the cases that you think from these last 10 years that you might mention. I know there are a couple already here, but other cases besides you. 1, 2, 3, 4, whatever. These are done cases.
Cases which have been
completing. In a book like this, in future, but from this decade, from the 2010, 2009, 2019 decade.
I think, Shekhar, the cases, I won't mention a particular case, but I think the cases which we'll really be thinking of are cases of the outliers. I think it's important that we focus on the cases which said, hey guys, there is a different perspective on the problem which you are addressing. Because I think the true value of the nation as it goes forward, I think today, is for us to accept that this is a nation of plural views. It's a nation of plural identities. It's a nation of a multitude of cultures. And it is really in this conflict of intellectual opinion, of a multitude of cultures, of identities, of thoughts, of process, that the true India which I perceive for the next 10 years should emerge. So we ought to really be valuing judges who constantly tell you that while we respect what has been laid down by our colleagues and which is today the prevalent view, judges who have said that I think we need to do things differently. I think that's where I would look to the future.
Madhvi?
Well, I think we've had so many very interesting and path-breaking judgments in the last 2 or 3 years. So I think.
Any problematic ones that you might think need dissection later or debate? No, I'm not saying that in the judgment.
Well, it's a court which doesn't necessarily speak in one voice. That we must acknowledge. So we don't know. It's very hard to predict what's going to happen. Shabrimala is going to be heard again shortly. So that is going to be an exciting one. Of course, Ram Mandir, Triple Talaq, these are really matters of 377. I think these are real epoch-making judgments.
So, let me also add one more question, which is that, say, in a country where judges' appointments are political, like America, you know how a judge or how a Supreme Court will rule on a certain issue. But in India, do we find sometimes these on largely social issues? For example, if you see the earlier judgment of 370, then it's the judgment of Haryana Panchayat, exclusion of no manipulates, and third, the judgment on the appointment of priests in Tamil Nadu. Now, one judgment is overturned within a few years, within 3 years or 4 years. Other two, I suspect, in the course of time will be questioned. So, do you find kind of a flavor of this season in the way Supreme Court speaks out of it?
I think it has always been there. That is one lesson which we learn from the book which is authored by Chintan, and we are doing Chintan about that. There would be one trend is there. As you know, the societal norms change, and therefore the Supreme Court is, or even the High Courts, are much more liberal in their approach towards these rights of people, and when it comes to what was the position about 20, 30 years ago. At the same time, it all again depends upon, as it is said, if there are 14 benches in the Supreme Court, there are 14 Supreme Courts. So it would depend upon, and that is one reason if you see what is happening when, which you rightly commented, a particular judgment delivered today, even within 1 week or 10 days, either in a review or otherwise, it would be referred to larger bench. That issues. And two cases which are pending here, which it said that the Sabrimala case is there. Aadhaar on one money bill is again referred to the 7-judge bench, and let us see what happens. And what I feel is that, as Marty rightly pointed out, in the last 3-4 years, many path-breaking judgments have been given. And if we add to the list of Zia's book, then it will be right to privacy is one judgment which would find the cases which shape the nation, and even this 377 judgment would be those, and in forgotten judgment, maybe those judgment making this adultery, decriminalizing the adultery is one judgment which should be referred to and which would be discussed. Yes, as far as issues in Sabrimala are concerned, they may be debated and discussed irrespective of whatever 7-judge bench also says for a long time.
Yeah. Which cases, besides the ones that you have listed as these?
So, very quickly, I think that, what I would be looking for the Supreme Court to do was to take every available opportunity to look at the gender biases and to use their jurisprudence to reshape thinking genuinely on the judiciary and therefore the citizenry at large. I think if we still look at what we have today, there is an unconscious bias. And how do we really change that? That is something that I would look forward to in the next 10 years. The trend has started. Danny always says she, but Danny is only one of very few. So the next thing that I would see is, our educational institutions, as you should say, Shekhar. The reservation issue is a constant struggle. Competence versus capacity building. How do we really draw the balance if we are to become a nation which gives access to students of competence? That is one. And then the last one I would say is national security, which is close to your heart. Chintan's cases talk about whether national security is a theme where the judges freeze a bit, go into jail mode, and government uses it as a get out of jail card for them. I think I would like to see in the next 10 years that balance becoming better. So if you look at the Tada case, ultimately it just died a natural death, not because of the Supreme Court, but it had outlived its 10 years. So how is that dialogue going to really come out in the future? We are a democracy.
Chintan, your next one?
So I can think of two sequels to this book. One of them is the cases that India forgot, part 2, in a decade from now. And the other is the cases that India forgot to decide. Let me start with the first one is, and my concern is, that the right to privacy judgment, which is perhaps the most significant, the most canonical judgment over the last decade, will be forgotten and will not be implemented in spirit. And the right to privacy judgment is one of those unique cases where everything is at stake. It's whether a fundamental right to privacy exists, but also on the other hand, nothing is at stake because there's no issue or list for the court to decide. And my concern is that the lofty principles and significant principles articulated in the court's judgment will not be applied robustly in practice. So it's one thing to articulate principles of the highest order, it's quite another to apply them robustly in practice. So that's the fear that I have. The other sequel could also be the cases that India forgot to decide. And this is really a matter of priority. Now remember, our court is like no other Supreme Court in the world. India's Supreme Court decides more cases in one day than the UK Supreme Court decides in a whole year. What that means is that there's naturally a queue, and some cases are more important than others and are waiting for others. What this results in is that significant cases are often simply not decided, are simply not determined until it's too late and you reach a situation where the issue is irremediable. And so therefore I think this idea of judicial avoidance is also something we need to think about. And the good and bad decisions that the court has taken also need to be considered in tandem with the decisions the court has simply avoided.
Thank you very much. We can go on for a long time, but I think we have to conclude this. Before I conclude, a couple of quick observations. First, NJAC. You mentioned NJAC, and I did write at that point that I'll be very suspicious of the law which gets passed so quickly in our party. Because our political system gets Victor Hugo upside down, which means he said nobody can stop an idea whose time has come. Our political system, nobody can stop a bad idea whose time has come. So a parliament which can pass almost no law without fighting, screaming, shouting, walkouts. Then they pass a law without any debate unanimously in 24 hours, you know that there is trouble. And that in my mind plants the seed of suspicion. That's one. The second thing is, you talked about a season when lawyer practice is a very lucrative. I have a different view on that in the sense of on the season. I think the season when legal practice became truly lucrative was the so-called fight against corruption season. That is the 2009 to 2015-16. I call it the Bentley season of legal practice. And it's a couple of judgments from that period which I would like to see some Chintan or Chintan himself talk about in the future. The 2G judgment, the coal judgment, the economic consequences of which are quite complicated even now. And once those are done like that, this is a weapon of mass destruction. It's a WMD, you can't fight it because it's now there. No bureaucrat will question it, no politician could question it. So these are things that have had a long-lasting effect. So those are things that have been repeated. And third thing, Nariman has gone. He paid you a great compliment by saying that we have the clarity of law telling. So on behalf of us journalists, I have a small request that when you deliver a judgment, or even when you have five different judgments, 5 judges right on one bench, give us what we journalists call a nut graph. Give us a paragraph saying what this means. Now that means, and you can make sure that that is not binding. A lawyer cannot go to the court tomorrow and say, you said this in the nut graph. But please idiot-proof it for us journalists. Because sometimes you delve into it, it becomes a little forbidding. So, and then you miss these subtleties and arguments as we might have in that Sabrimala. So I think on that note, congratulations. Thank you very much and thank you all.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.